jobs.com, and it's a very good website too. Well, since the start of the recession, we've had stories too of people working longer hours for less pay, and that they've become quite common. And with people these days just glad to have a job, many seem prepared to just grin and bear that extra work pressure. But when does hard work become exploitation? We're joined now by Naas solicitor Liam Moloney, who is an employment law specialist. Liam, what's going on?
Well, basically, power has shifted to the employers since the recession began. We've seen an increase in the number of claims going to the Employment Appeals Tribunal on behalf of workers. In a lot of cases where workers haven't been provided with proper contracts of employment, haven't been paid for overtime, are being asked to work excessive hours with no rest period or breaks, and employers in a lot of cases are failing to abide by employment legislation.
Now, you say you've seen an increase in cases. What kind of an increase in number of cases?
Well, the Employment Appeals Tribunal in 2009 dealt with just under 9,500 cases, and this year it's over 10,000. And if you compare it back to 2008, there was 5,500 cases lodged with the Employment Appeals Tribunal. So there's been a massive increase in the number of claims coming before the tribunals. And unfortunately, the waiting list for cases to get on has nearly trebled since 2007.
So when you say trebled, how long would it, like if somebody has a complaint and they do take it to the Employment Appeals Tribunal, how long is the waiting?
The waiting list can be in excess of 52 weeks, nearly a year. And then when your case actually gets before the tribunal are now taking longer to deliver decisions. And this is a completely unacceptable situation because it means people are involved in litigation for, in some cases, in excess of 16 months. Well, these cases should be dealt with far quicker than that. And there's no reason why the tribunals can't issue their decisions far quicker.
Well, now, you said that what are some of the issues related to working time and so on. What kind of hours are people working these days?
Well, in some of the business or the industries that I would act on behalf of employees would be low-paid, unskilled workers in the food industry, meat factories, hotel sectors. In some cases, they're being asked to work in excess of 60 and 70 hours per week, and they're not being paid the proper wage rates applicable to their various industries. And employees are very vulnerable in the first 12 months of their employment because they're not covered by the Unfair Dismissals Act. So in the first 12 months of their employment, they can be dismissed and they have virtually no remedy.
Is it a case then that when they're working all those extra hours, they're only being paid for the 40?
Essentially, they're being paid a flat rate. They're not, in many cases, they're not being paid the applicable overtime rates that apply to their industry. And employees are very concerned and worried that if they make complaints to the Labour Court, that they'll be victimised and as a result lose their job. And within the first 12 months, if they do lose their job, they have virtually nowhere to go with their complaint. They're not covered by the Unfair Dismissals Act.
You say that a lot of the people who you work with are in low-paid industries. What about higher-paid industries?
Even in higher-paid industries where there are mechanisms in place where people have contracts and there are policies and procedures, again, there is a worry or a concern on behalf of employees that if they do challenge their employer, that they will be victimised. And the difficulty now is where people, if they are made redundant or if they're chosen, if a redundancy is in the offing and an employee has raised complaints to HR, has brought complaints to senior management, that they fear that they will be chosen then if a redundancy situation arises. And obviously the difficulty now is in this economy that it's so hard to get another job.
So people are very vulnerable.
People are very vulnerable, particularly in the first 12 months.
Well, after the first 12 months, obviously things change. But one of the things, 12 months or otherwise, and people who are in jobs for a long time, is redundancy and this whole issue of redundancy. And I understand that the number of claims at the Employment Appeals Tribunal for redundancy is up fourfold in the last couple of years or more.
Most of the cases at the moment...
What is the problem with redundancies? Is it that people are not getting paid enough for the redundancy, or why are they going to the tribunal?
There are two problems really with redundancy. The first problem is people aren't getting their redundancy payments. Once you're employed for over 2 years, you're entitled to a redundancy payment. And in many cases, the employer is pleading inability to pay. And then the employee has to take a claim to the Employment Appeals Tribunal or take a claim to the Minister for Industry, Enterprise, Trade and Employment under the Insolvency Fund. And again, there are long delays in getting these payments. If you make an application to the department, it takes in excess at the moment of 6 months or longer to actually get the redundancy payment. That's the first matter that will come before the tribunal. The second issue that comes before the tribunal is in relation to unfair selection, where employees feel that while the business is still ongoing, that they have been selected unfairly for redundancy, and they're challenging the redundancy decision to make them redundant.
And that must be difficult to prove, I presume. Why or is it?